Are you ready for the last lecture for our class? Today's topic will be the judiciary. So this topic will be approached in this way. First of all, I'll describe the different types of courts at the state as well as the national level. Then we'll address some of the traits of the judiciary with the Constitution. I'll talk about the process by which the courts decide to hear cases, and then we'll explore a few examples of some key cases that have had a major impact on American history. So let's look at the types of courts at the state level next. Now I'd like to start with the concept. Most courts and most trials in the United States take place at the state level. Not the national level, but the state level. Most courts that you're familiar with are trial courts. These are the ones that are shown most often on TV. This is the first court to hear a case, whether it's a criminal case, whether somebody has violated the law or not, they're trying to determine guilt or innocence, or a civil case where someone sues someone else for money. Either a judge or a jury determines the guilt or the innocence of the person who's on trial. Another type of court at the state level would be an appellate court. After there's been an initial trial, the person who loses can appeal that decision. Generally speaking, an appellate court has either 3 or more judges. People don't go there and testify. What the judges do is they look at the original trial and they try to make sure that correct processes were followed. Next, we will define a couple of terms. Most criminal cases are actually settled before they come to trial. That's because the two parties agree to a plea bargain. This is where someone who's accused of a crime actually pleads guilty. The prosecutors like to do this because it helps to prevent a backlog of cases because the cases can take forever and ever. Why would a defendant do this? Well, usually the punishment for a crime is reduced. The next term would be precedent. This is an important concept in our legal system. It comes from the Latin phrase stare decisis, which can be translated to mean let the decision stand. Essentially, previous cases that are similar serve as examples to guide judges as they decide on new cases where similar incidents take place. And so the decision in a previous case is followed and is a role model for future cases. Next, we'll explore the judiciary at the federal or the national level. There are over 90 different U.S. district courts throughout the United States. I'll show a map next. This is a map of the different federal courts located in the United States. If you look at Michigan, Michigan is divided into 2 federal courts. If you violate federal law in Michigan, you could go to the eastern half or you could go to the western half, which is located in the western half of Michigan, but it also includes the UP. If you look at another state, a small state like Montana, it doesn't have a huge population. There's only 1 federal court there. The same is true for Colorado. Now, if you look at Texas, Texas is not only a physically large state, but it's also got a lot of people in it. So if you notice those dotted lines, there are numerous federal courts in the state of Texas. In addition to those district courts, there are 12 regional circuit courts of appeals. Essentially, if you're convicted of a crime in a U.S. district court, well, you can appeal that conviction. Where would you appeal it to? Well, to one of these circuit courts of appeals. Here we are back at that map. Notice Michigan. It's kind of in the brown area. Michigan is located in the 6th Circuit Court of Appeals. Other states included in our district would be Ohio, Kentucky, and Tennessee. Now, if we go further to the west, the 9th Circuit includes California and numerous states in the American West. I should mention one additional Court of Appeals. The United States Supreme Court, located in Washington, D.C., is the highest court of appeals. So if you're convicted of a crime in a district court, you could appeal to the circuit court, and if you still lose, you could appeal again to the United States Supreme Court. Here we see the Supreme Court building, located very close to the United States Capitol, right in Washington, D.C. I was lucky enough several years ago to have a tour of the Supreme Court building. This is the closest I got to taking a photo in the actual courtroom. They don't let you take any photos there, but it was a really good tour. Well, after I got back from that trip, I went on the Supreme Court's website, and I got this photo. Go figure. Next, we'll explore the qualifications to serve in the federal judiciary and some other aspects of the Constitution. Previously, we explored the qualifications outlined in the Constitution to serve in the House, the Senate, and the presidency. Well, the Constitution says absolutely nothing about qualifications to serve in the judiciary. There are none. But, generally speaking, candidates have a background in the law, and they're also usually members of the president's political party, or at the very least, they have similar views as the president. Candidates for the judiciary generally have similar views as the president because of the selection process for Supreme Court justices and federal judges. There are two steps in this process. First of all, if there's a vacancy, the president has the sole authority to nominate someone to fill it. Secondly, the United States Senate has the authority to either confirm or reject a candidate. They must vote in favor of someone by a majority vote. Once someone has been confirmed, they receive a lifetime appointment as long as they continue with, quote, good behavior. The gentleman shown here is William Douglas. He set the record for the longest serving justice. It was a little over 36 years. There are 9 members of the United States Supreme Court. They're shown here. In the middle is John Roberts. He serves as Chief Justice. The most important responsibility of our courts is judicial review. Here's a textbook definition of this concept. It's the authority of our courts to declare laws or actions of government officials to be unconstitutional. It's a crucial power and difficult to overestimate. While judges do hold lifetime appointments, they can be impeached and removed from office. It's the same process to remove someone from the judiciary as it would be the President of the United States. There's a special process that one must go through if you want your case to be heard by the Supreme Court. We'll explore that next. According to your text, on average, the Supreme Court receives about 8,000 petitions of people who would like them to hear their case. In general, fewer than 100, maybe as many as 100, but about 100 are chosen to be heard. No one can force the Supreme Court to hear a case. They have complete discretion on which cases they decide to hear or the ones that they refuse to hear. The process is called a writ of certiorari. This can be cut down or shortened to the rule of 4. What happens is that if someone wants their case to be heard, they file a writ, this writ of certiorari. They outline their case. 4 justices must agree to say, yes, we'll go ahead and take this case and review a lower court decision. Without those 4 votes, a case is not heard. If a writ of certiorari is granted, then attorneys for both sides are allowed oral argument at the Supreme Court, but it's strictly limited. Generally speaking, they get 30 minutes each. Often, they're interrupted by questions and comments by the justices, but they get their opportunity to make a case. Following oral argument, the justices meet in their conference room. Generally speaking, these take place on Fridays. Only the justices are allowed to come in private to discuss the week's cases. Their goal is to reach a majority decision as quickly as possible. Maybe they'll be able to get a consensus right away. It might take several meetings. Once a decision is determined, then they write their reasons for taking that position, and then an announcement is made. Numerous court cases have been heard by our Supreme Court. I'd like to identify 3. The first of these court cases is Marbury versus Madison. I'd like to offer a little background first. What happened is that John Adams was president, but he was at the end of his term. On the last days of his administration, he appointed several so-called midnight judges to different offices. The new president was Thomas Jefferson. He refused to recognize several of those appointees. One was named William Marbury. He sued because he said, hey, I was supposed to get this new job as a judge. The Chief Justice at the time was John Marshall. Marshall ruled that the Supreme Court could not protect Marbury's appointment because there was no provision in the Constitution protecting him. This asserted the Supreme Court's right to judge the constitutionality of laws passed by Congress. It was important because it established the precedent of judicial review. Another court case was called Gideon versus Wainwright. It's from the 1960s. Clarence Earl Gideon is shown here, and he was accused of breaking and entering. He was arrested, put on trial. At his trial, he asked for an attorney, but it was denied. He was convicted. He then appealed to the Supreme Court. The Supreme Court heard his appeal, and they granted him a new trial because he didn't have an attorney, and he had asked for one, and he couldn't afford one. This established a new precedent. If people couldn't afford an attorney, one would be provided for them. The next case was called Miranda versus Arizona, and it involved Ernesto Miranda, as shown here. Following a series of crimes, Miranda was called in by the police. They questioned him. Miranda confessed to committing those crimes. However, no attorney was present. His conviction was appealed to the Supreme Court. Eventually, the Supreme Court required the police to advise people of their rights. You have the right to remain silent and the right to an attorney. Let's review some of the key concepts included in this presentation. What you should be able to do by now is to be able to explain the different types of courts there are, and also to address the Constitution on our courts, qualifications, the powers that our courts have, and the process for hearing cases. Also, you should be able to highlight any 2 of the 3 cases that were described and evaluate which you believe to be the most important. Well, this concludes the last lecture for our class. Take care, have a good day, and good luck on the final exam.